Children and Family Affairs Subcommittee meeting January the 10th, 2026. We're going to begin with a prayer by Chairman Bolso, and then we'll stand, and please remain standing for the pledge.
In the Father, and the Son, and the Holy Spirit. Heavenly Father, thank you for bringing us here today. We ask your special blessing today upon those children in Tennessee for whom we are going to be litigating over these bills. We also ask that you send your blessings upon their parents, upon everyone working in the state government to protect children, especially those representatives of DCA who have such a difficult job. And then finally, we ask, Father, that you also give us the grace to understand that we act in the best interest of children in Tennessee always. We ask all of this through your Son, our Lord Jesus Christ, and the unity of the Holy Spirit, one God forever and ever. Amen. Thank you, Father, and the Son, and the Holy Spirit. Amen.
Would you join me in the pledge? I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All rise. Thank you. Thank you. Love you, man. Love you too, brother.
Okay, is everyone signed in? Madam Clerk, would you open the board and take the roll, please? Madam Clerk, would you take the roll, please?
Madam Chair, you have 5 members present. You have a quorum.
Thank you. Members, do we have any personal orders? Okay, well, we seeing none, other than Deborah Moody being here. We have some quick housekeeping. House Bill number 1, House Bill 2526 is rolled to the Hill. Number 2, House Bill 2527 is rolled to the Hill. Number 5, House Bill 2262, rolled to the Hill. Number 11, House Bill 1939, rolled to the Hill. House Bill 2250, rolled to the Hill. Number 14, House Bill 2128 has been taken off notice. So without objection, we're going to start with number 3, House Bill 1904 by Chairman Terry.
Motion.
Probably motioned and seconded. You are recognized.
All right. Thank you,
Wake up,
Chair Lady. And I do have an amendment that makes the bill 014680.
Okay. Do you want to go ahead and put that on the bill?
Yes, please.
All those in favor of
I need
I'll need a motion in a second.
Oh, second.
Second motion.
okay. All of those in favor of putting a House Bill adding Amendment 14680 to House Bill 1904, say aye.
Aye.
Those opposed, no. You are recognized on House Bill 1904 as amended.
Thank you, Chair Lady and committee. And it's my first time, I think, to ever be in front of your committee.
Well, welcome aboard.
So thank you. So what this bill addresses is a narrow but important issue involving child custody proceedings when a child is identified as a Native American child. Currently, Tennessee courts follow the standards established under the Federal Indian Child Welfare Act. It's often known as ICWA. So in 2023, the U.S. Supreme Court upheld the constitutionality of ICWA in the case of Holland versus Brackeen, affirming the Congress's authority in this area. As a result, ICWA continues to govern these proceedings, and this is that's a positive, and this bill does not change that. However, herein lies the issue and why this legislation is necessary. If Congress has the constitutional authority to enact ICWA, as the court confirmed, then also has the authority to amend or repeal it. And so the bill before you ensures that if federal law were to ever be repealed or significantly changed, Tennessee would not suddenly find itself without the framework for handling these sensitive cases. Instead, this bill functions as a safeguard maintaining the same procedures and protections. Tennessee courts currently fall under ICWA until this legislature, it would continue to follow under ICWA until the legislature has time to review the issue and determine the appropriate state policy. So basically, in other words, what we're doing is in the event that ICWA goes away, we would, this would be act as a trigger. We would follow ICWA so that we can get together and determine how we would like to handle that situation.
Are there any questions for Chairman Terry? So it would remain the same but give us, like, if it's changed federally, then we would have the opportunity to change it.
Thank you. Great question. So in the event that something changes at the federal level, we would have a buffer to where we would come back. This would still be in place. We could come up with how we would want to do it. I'm not going to, I'm Native American. I'm not going to be up here for forever. I don't suspect that it was going to change, but in the event that it does, those that are up here will have a time frame to where these children aren't set aside and under a different policy. We'd be able to institute our own tailored for them.
Okay. Any other questions? Seeing none, are we ready to vote? Would you please open the board? All those in favor of House Bill 1904 as amended, vote aye. Those opposed, no. Madam Clerk, would you take the vote, please?
Madam Chair, you have 4 ayes and 0 noes.
Your bill moves out to judiciary. House Bill 1904 as amended moves out to judiciary.
Thank you, Chairman.
Okay. All right. Next up is number 4, House Bill 1734 by Chairman Moody.
Motion. Second.
Properly motioned and second. You are recognized, Chairman Moody.
Thank you, Chair Lady Littleton and committee. So today,
And I see that you do have an amendment.
yes. And that amendment does make the bill.
All right. So you want to go ahead and put that on the bill?
Yes.
Okay. So I thought did you give us the draft? of that?
Yes. 014715.
Okay. Thank you. So all those in favor of Amendment 014715 going on to House Bill 1734, say aye.
Aye.
Those opposed? No. The ayes have it. You are recognized on House Bill 1734 as amended.
Thank you again so much for that. This came, Chair Lady Littleton and I, of course, have been blessed to be in the fight against the human trafficking issue in our state, our country. And so we were at a meeting where they talked about the Gracie Act. And we looked at each other and thought, man, that sounds good. We ought to do that.
I think we fought over that bill, but I'm not saying.
But what we've done is we have tailored this. We've come off the Gracie Act. We modeled some of it. We didn't take all of it. So that's what this amendment will do. What we would like to do, and I want to give a shout out to working closely with Stephen Warner, who is here, and Margie Quinn, our Commissioner of DCS. We hashed out what we thought would be best to make this a Gracie Act for Tennessee. And so what this will do, we will create a pilot program. And the one thing both of these, the people I mentioned here, wanted to be sure, the Gracie Act required audio and video, and they wanted it to be audio only. So this is the difference in ours and the National Act. We will be audio only. And since this is just a pilot program, they wanted to let one county be that pilot program. And I think I know which one, but if I don't need to say yet, just let it be one county. And they have chosen, I will assure you, the county that they have chosen is number one in handling these kind of cases. So of course, when you're interviewing children under these cases, it's a very tender and hard thing. And so we felt like this would be the best way for trying this out in Tennessee and see what data we get back, and maybe coming back to you later with a bigger thing for our state. So anyway, I hope that made sense.
Are there any questions for Chair Lady?
I do, I'm sorry. I do have,
Would you like for her to?
would you like to come up?
I'd be happy to.
I've said her name 3 different ways, and
Well,
I'm
say
not
it
trying.
again before I go out of session.
Well, I keep calling her Camilla, but it's
It's
Kamala. But I'm
Okay.
not saying her last name.
Okay.
'Cause-
Well, we're going to go out of session and hear from Kamala, and I'm not going after that last name. We're out of session. Just state your name and who you're with.
I will. My name is Kamala Zulfagari. I do say it wrong according to my in-laws. I was Kamala Wright when I graduated from Tennessee. Thank you. I am a Street Grace. Street Grace is one of the 4 single points of entry for victim services, and we actually cover the area where we believe this will be piloted. We've been actually working on the Gracie Act with Senator Blackburn on a national level, hoping to get funding for this. I love the way Tennessee is approaching this. We want to make sure that our children are protected by making sure their interviews are being recorded and accurate. My background is as a human trafficking prosecutor, and before that, a child abuse prosecutor. And the importance of really knowing what the children said are important for the children. It's also important for the families. This is also a parents' rights bill. It was actually first brought up by an adoptive family who's adopted many kids out of Child Protective Services, and they have no idea really their history, because the interviews from Child Protective Services are some handwritten, were handwritten notes typed in, not what was actually recorded. We record our interviews. Law enforcement records their interviews. A lot of our doctor's offices are starting to record our interviews. If we record them, and audio is absolutely appropriate, then we'll have the most accurate stance. It also keeps children from having to repeat their stories. If they have told someone, we want to make sure when they go for their actual forensic interviews or when they talk to the next person, somebody knows what they've actually said so that they know they're being listened to. Nationally, 37.4% of our children will be interviewed by Child Protective Services at some point. This really touches on everyone. So we really thank you for considering this and hope that you will pass it, and then we'll keep moving on. Thank you.
You did really good with your time. Would you like, there might be a question for you. Are there any questions? Seeing none, thank you so much for being here. We appreciate that.
Thank you, Chair.
So we are back in session. Chairman Moody, you are recognized.
Well, it's everything that she said, and again, I'm grateful for our local people here in Tennessee that were agreeable to hash things out and get on the same page on this important issue and get us started on having a better idea of which direction to go and get this straightened out and protect our children as much as we can. So appreciate your vote.
Thank you for taking that bill.
Thank you.
It's a great bill, so I look forward to voting for it. So
Yes.
thank you for doing
Thank
that.
you. Thank you.
Any other questions for Chair Lady Moody? Seeing none, are we ready to vote? Okay. Madam Clerk, would you open the board? All those in favor of House Bill 1734 as amended, vote aye. Those opposed, vote no. Clerk, would you please take the vote?
Madam Chair, you have 4 ayes and 0 noes.
Thank you.
It's a miracle. Thank you. Thank you.
So, House Bill 1734 as amended moves out to judiciary full. Next on the agenda, we have number 6, House Bill 2443 by Chairman Rutter. Chairman Rutter, you are very lucky. There are no amendments.
No amendments. That is very,
Properly
very
motioned
good.
and second, you are recognized. Okay, properly motioned and second.
Thank you, Chair Lady Littleton. This bill was brought to me by the DAs, and I want to point out it has support of DHS. And this is a very straightforward bill. It specifies that parents' obligation for support of a child does not continue after that child reaches the age of 19 years of age unless the child is handicapped or disabled, regardless of where that child is in the education system. And that's the bill. I would
Any-
appreciate your support.
Any questions for Chair Lady Rudder? Seeing none, are we ready to vote? Okay. All those in favor of House Bill 2443, vote aye, and those opposed, no. Madam Clerk, could you take the vote?
Madam Chair, you have 4 ayes and 0 noes.
Thank you. So House Bill 2443 moves out to full judiciary.
Thank you, Madam Chairman and committee.
Next up is number 7, House Bill 2283 by Chairman Carringer.
Motion.
Properly motioned and seconded. And I see that you do have an amendment.
Yes, I do, Chairman. It's number 013839.
And does that make the bill?
Yes, it does.
Okay. Do you want to go ahead and put that on the bill?
Motion on the amendment.
All those in favor of putting Amendment 13839 onto 2283, say aye. Those opposed, no. The ayes have it. So you are recognized on House Bill 2283 as amended.
Thank you, Chair Lady and Committee. Current law authorizes the Department of Children's Services to place children removed from their home in the care of a relative caregivers. Currently, relative caregiver is defined as a person within a first, second, or third degree of relationship to the parent or step-parent of a child who may be related through blood, marriage, or adoption. This bill prohibits DCS from requiring a relative caregiver to provide the child with the child's own bedroom unless there are specific safety or medical reasons that would make placement of the child with another child unsafe. The intent of this bill is simply to make it easier for the department to place children in the care of a relative caregiver. The amendment was worked on with the department, and it simply clarifies that the prohibition applies both to the department and any court order that grants custody or guardianship. So with that, I'll stand for questions.
Are there any questions for Chairman Carringer? Seeing none, are we ready to vote? All right, let's vote. Would you please open the board? All those in favor of House Bill 2283 as amended, please vote aye. Those opposed, no. Would you please take the vote?
Madam Chair, you have 5 ayes and 0 noes.
Thank you. So House Bill 2283 moves out to judiciary full as amended.
Thank you, Chair Lady and Committee, especially that one up there that makes you all kind of nervous.
You're out of order. Out of order. Okay, next is number 8, House Bill 2154 by Representative Raper. And I think the amendment is on there, so you are recognized on, right?
Yeah, the amendment's on there. Oh, no, it's fine. Yeah, no, we're good. We
Okay.
can motion in a second.
Motion on the amendment.
No, the amendment's already on there.
It's on there, okay.
Oh, I thought we already had the motion.
Yeah.
Okay. Okay. You're recognized on House Bill 2154.
Thank you, Madam Chair and committee. This bill requires court-appointed guardian ad litem in divorce cases involving minor children to complete training by a qualified professional in 3 areas: early childhood development, child development, and adolescent development. And essentially, from that point, I'm just going to wrap it up in saying this is if the attorneys that will end up being guardian ad litems, if they have not had the proper training in those 3 areas I just suggested, this bill allows them 3 more years to obtain that. And it's virtual, by the way. But other than that, I do have speakers from AOC that I'm so appreciative of them coming. And if you have questions about the training, anything like that, they are here to explain to you. So, and other than that, I renew my motion.
Members, do we understand, or do we want, we're good? Excuse me. You're recognized. There you go. All right. All those, would you please open the board? All those in favor of House Bill 2154, vote aye. Those opposed, no. I guess yes. Would you take the vote, please?
Madam Chair, you have 5 ayes and 0 noes.
Thank you, Madam Chair and committee.
House Bill 2154 moves out to judiciary approval as amended. Next, we have item number 9, House Bill 590 by Representative Ashley.
Motion, second.
Properly motioned and seconded. You're recognized.
Thank you, Madam Chair.
I see you have 2 amendments.
I have a new amendment that makes the bill 014970.
Is that the one you want to go with?
Yes.
Okay. Properly motioned and second. Does it make the bill? You want to go ahead
Yes.
and put it on?
Yes.
Okay. So all those in favor of adding Amendment 14970 to House Bill 590, say aye. Those opposed, no. The ayes have it. You are recognized on 590 as amended.
Thank you, Madam Chair. This bill was brought by Senator Massey, and it passed the Senate today. It requires a court that is determining a child custody order to consider the best interest of the child as paramount consideration. Requires the court, without creating any presumption as to parenting time, the extent to which the parenting schedule proposed or ordered provides each parent with meaningful opportunities to participate in the child's life consistent with the child's best interest. This is just adding this to the list of factors is the one more factor.
Are there any questions for Representative Ashley? Seeing none, are we ready to vote? Okay, all those in favor of House Bill 590 as amended, vote aye. Those opposed, no.
Wrong button.
Madam Clerk, would you take the vote, please?
Madam Chair, you have 5 ayes and 0 noes.
Thank you. So House Bill 590 as amended moves out to judiciary full.
Thank you, Madam Chair and committee.
Next is item number 10, House Bill 1693 by Representative Renaud. Properly motioned and seconded. I see that you have 2 amendments.
We are just putting on one of them. That would be 014515.
Okay. Properly motioned and second. Do we want to go ahead and put that on? Let's do that. So all of those in favor of adding 14515 amendment to House Bill 1692, say aye. Those opposed, no. The ayes have it. You are recognized on House Bill 1692 as amended.
Thank you, Chair Ladies Committee. This under current Tennessee law, there are certain procedural allowances that allow, in adoption cases that allow for a child when they're related to a petitioner to have these things I'm asking to be waived for someone where the non-petitioner is unrelated. This extends the same recognition to those children who've already lived in a non-related petitioner's home for at least 6 months under a prior court order. Courts do not grant this lightly. Before doing so, a judge has already considered the suitability, the safety, and the child's best interests, often with oversight from court reports, court-appointed special advocates, and other hearings. So the court has already made an informed opinion about the home. So this bill does respect that. Today, under current law, whenever a petitioner is related to the child, a distant relative by marriage can actually bypass these steps that the non-related person has to do. And so the reason why I feel like we should be able to extend this to the non-related petitioners is because caregivers, when they've already done the same steps that the court has already, or these other non-family members have done, but have provided for the care for the child, have taken financial responsibility after a court has already determined that it's a safe, proper placement for the child, we should expedite permanency for that child. What this bill does is grants judges the opportunity and the discretion to waive the steps for a home study, which would also, there's a 6-month waiting period after the home study before permanency is granted. They're never required to do this. The courts retain the full authority to order studies or investigations or deny adoption if there are any concerns at all. So this bill just trusts judges the same way that we already do for cases where a relative is involved. So we did our best here to keep the safeguards, to allow judges to have this discretion. And really the goal of this is to reduce any unnecessary duplication in that permanency process for someone who has already been placed in a home. With that, I stand ready for questions.
Are there any questions? Seeing none. Judge? Okay. Okay. Question's been called. Without objection, we'll be voting on House Bill 1692 as amended. All those in favor vote yes. Those opposed, no. The ayes have it. Clerk, would you please?
Madam Chair, you have 5 ayes and 0 noes.
Thank you. Okay, so House Bill 1692 as amended moves out to judiciary full.
Thank you, Chair of the Committee.
So we had a what about Alexander's here? Let's just go down. Next up, we have number 13, House Bill 2127 by Representative Alexander.
Would you like me to go down or can I
No,
do it from here?
This is good.
Okay. All right.
A
Great.
witness. We do.
Do you need to put an amendment? I guess
Yes,
I need a first and a second.
First, and a second. You guys.
We're not with it today.
You recognize.
Okay. All right. Thank you, Chair.
In a minute, you have the amendment.
015027.
Okay, does that make the bill?
Yes, it does.
Well, let's go ahead and put that on the bill. I thought we had a motion. Do I have a motion and second on the amendment?
Second.
All right. Okay, so you're recognized on House Bill 2127 as amended.
Okay. Basically, what this bill does is the doctrine of judicata does not preclude admission of evidence concerning a parent's caregiver's conduct that occurred prior to the entry of the most recent parenting plan, which such evidence is relevant to the child's best interest. As used in this subsection, evidence includes, but is not limited to, sworn testimony, medical and mental health records, psychological evaluations, police reports, child protective services, school and child care records, audio, video, and photographic documentation, expert witness findings, previous court dockets, and any documentation or credible reporting by professionals mandated to report child abuse or neglect. In determining the best interest of a child, the court shall give the highest weight to credible evidence of physical abuse, sexual abuse, or domestic violence. The weight must be applied equally to abuse committed against any member of the child's household, including siblings, half-siblings, foster siblings, and step siblings. And lastly, a court that issues a custody order, whether temporary or permanent, must take in consideration all of the restrictions. This bill does nothing but protect a child from being put back into an abusive home.
Yes, what is it that the amendment actually does, Representative?
It just was 4 words, whether temporary or permanent.
Okay.
That's what it did.
Are there any questions? Do we have any questions for Representative Alexander? Seeing none, are we ready to vote? All those in favor of House Bill 2127 as amended, would you please up the board vote aye? Those opposed, no. Madam Clerk, would you please take the vote?
Guess I should vote for my own bill.
Madam Chair, you have 5 ayes and 0 noes.
Thank you. So House Bill 2127 as amended moves out to judiciary full.
Yes. Chairman, can I make sure that we have that drafting code on that amendment correctly? Because that was 015027. Did I give you
That's what I
that
had.
correct?
Mhm.
Okay,
Thank you.
thank you. The second bill is also my bill.
It's off notice.
And it is on notice. I just asked if I could speak about this bill so you can know.
Well, then you are recognized on House
Okay.
Bill 2128.
Okay.
Representative Alexander.
This is a bill that would do a child's rights. But from my understanding, since they started doing this bill, we found out there is already a Child's Bill of Rights in code, and we just want to be able to expand that. We want to work on it and maybe do something different next year with TBA was great to help me with this, and I thank them for their willingness to work with me on these bills.
Okay, thank you for that
Thank you.
explanation.
Move it out.
Okay, we're going to go out of order and pull up Representative Johnson's bills. That would be item 11, House Bill 1939. You are recognized on House Bill 1939.
Thank you, Madam Chair. So this bill is in reference to DCS caseloads. I have had this bill in the past, and unfortunately, we are seeing some of the same things that we saw 2 years ago. There was a lot of money allotted to DCS to help with the fact that they were behind on a number of employees. People had up to 90 per caseload, and we were seeing kids put in transitional housing and in office. There have been kids sleeping in offices this year again. We have got DCS workers that are strained because in addition to their caseloads, they are also having to watch kids who are in these transitional settings. Kids are they say that as of this month, they have not had kids in offices. However, they are in traditional transitional housing, which is basically like an office, yet it has a bathroom. It's not much better. And DCS workers who have caseloads have to go and sit and watch them all day long. And so when their caseloads are far beyond what they should be, the social worker standard is a maximum of 12 cases and then a maximum of 20 kids, because sometimes in those 12 cases, you might have multiple kids in a family, and sometimes you get a lot of kids. So what this does is use the social work standard to say that we're going to have only 12 on a caseload and that we are going to and only allow 20 kids also as a cap. Currently, we have a round figure, and it's allowing us to get up and over the numbers that are healthy for our kids. Once again, this bill also makes it so that cases need to be closed as they can within a year. If they cannot be closed in a year, then they can go before the judge and say why this case isn't closed, why it hasn't been taken care of then. But this is because we have got so many kids right now, and so many DCS workers are leaving again because their caseloads are too large. And in addition to their large caseloads, they are assigned to sit in facilities and watch kids. And they're not trained. A lot of times, these kids are autistic, these kids are deaf, and they're not trained to work with those kinds of kiddos. And it's putting our kids in great danger and great risk. That's what the bill does.
Are there any questions? I think DCS wanted to speak on this, so we'll go out of session and hear from them. We're out of session. Please introduce yourself and who you're with, and the two of you together have 5 minutes.
Thank you, Chair Lady and committee members. My name is Jim Lehman. I'm the Legislative Director for the Department of Children's Services, and Hayes O'Donnell here with me, our Assistant Director. The department does have a position of flagged philosophically and flagged for fiscal reasons, and we were able to meet with Representative Johnson earlier today to discuss those. The fiscal note, I think, is on this one's around 16 million. The philosophical opposition comes from two things. The second part of the bill has sort of this very arbitrary closing of cases within 12 months and says DCS must close cases within 12 months. It is not, we are not even probably the primary driver of how long cases are open. These cases are before juvenile court. So there, are all sorts of factors beyond our control on how long cases stay open. The courts, availability of services, what the parents are doing primarily. A lot of times cases stay open until the parents can do what the court asks them to do. So had opposition to that. And then when it comes to the caseloads, look, we would love to lower caseloads. We want our caseloads lower, but putting, a hard cap number in the law isn't what is going to lower caseloads. What will lower caseloads is additional staff, lowering the total number of kids coming into custody, making things more workable for our staff so that, we're able to retain them and have them stay and serve their children. So that was kind of where the philosophical opposition came from, and we're happy to answer any questions you may have.
Are there any questions for DCS? Chairman Doggett.
Oh,
you're
thank you,
recognized.
Madam Chair. But in a perfect world, if you had enough case workers to where they only averaged 12 apiece, would that not be awesome?
It would be awesome to have, a number that low. Absolutely.
Because that's what I hear from a lot of mine is that they're overworked. They've got a lot, their caseload continuously grows day in and day out. So I would hope that we would be moving in a direction where we could get more employees and lighten that caseload going forward.
I think Hayes may have some additional information about caseloads in general if you want.
Yeah, thank you so
recognized.
much. Thank you, Chair Lady. Hayes O'Donnell, Assistant Director of Legislation, Department of Children's Services. One of the first things I'd like to mention is whenever we have our new case managers coming on board, we have taken a lot of feedback from that. We have altered our training to make sure that they feel comfortable and confident with the information that's coming on. We've also implemented internal policy that does cap the caseload of a new case manager in that first year of their work at 10. Part of our budget request this year, which was approved by you all, and we do greatly appreciate that, was more for private provider case management to assist with this as well. We regularly track our caseloads, and we also regularly track our case manager, both coming in and out. And we take all that feedback very seriously and to implement that with internal policy and projections.
Thank you.
Anything else?
Thank you.
Any more questions for DCS? Representative Kiesling, you're recognized.
Thank you, Chair Lady. Dovetailing off of Chairman Doggett's question, Jim or Hayes. So the judiciary, they're the ones that they're not. Have you guys tried to meet in the middle, or is that even possible? Because I do understand that it's the judiciary that sometimes is causing this caseload. Is that correct? Jim, if you could, Madam Chair.
You're recognized.
Well, I think our point was just the length of the cases is not necessarily only a function of DCS. It's a function of the courts themselves, the parents themselves, how quickly they can meet their obligations of the permanency plan, that sort of thing. Sometimes just availability of services. That was the point we were trying to make there. And we did, Representative Johnson may speak to that. She did show some openness to revisiting that section of the bill. But we didn't have a chance to talk about it until a couple hours ago. So.
Chair Lady.
You're
Yes.
recognized.
And so am I, as Chairman Doggett mentioned. I'm hearing the same problem. I mean, from my folks up up my way. I mean, they're just overloaded. And I don't know. I don't know where the magic wand is here. Do we? Do we not? But anyway, that concludes. Thank you, Chair Lady. Thank you, Jim. And
Any other questions for DCS? Seeing none, we're back in session. Thank you. You're recognized.
Thank you, Madam Chair. And I think it's really important when you say that there's a fiscal note of 16 million, that shows you how far behind we are in serving these kids and how many more people that we do need. They have, when I had this bill a couple of years ago, they have been adding people, but the problem is people tend to leave because they just can't handle the load. It's incredibly stressful because when you're dealing with DCS, not only are you overworked, but what your fear is when you talk to those DCS workers is this is about troubled kids and kids in horrible situations. And when you can't meet their needs right then, when they've been removed from the home, it's such a dangerous time for them. And it is so traumatic. Not being able to be what we need to be to those kids is important. And we've got to find a way to make this work. Other states have done it. They've done it with, caseloads and that type of thing. But we are putting kids in dangerous situations at the worst time in their life. And we have got to find a way to do better. And a caseload cap is a great place to start.
Any other questions? We ready to vote? Madam Clerk, open the board. All those in favor of House Bill 1939, say vote yes. Those opposed, no. Would you please take the vote, Madam Clerk?
Madam Chair, you have 3 ayes and 2 noes.
House Bill 1939 moves out to judiciary full. Next up is number 12, House Bill 2250 by Representative Johnson.
Can I get a motion?
Motion.
You're recognized on House Bill 2250.
Thank you. This bill is broken into 2 parts. Section A covers data transparency related to the Department of Children's Services provider network for placing children in custody, and covers data transparency related to the use of temporary placements and children in DCS custody. So there's currently no publicly available information regarding where children are being housed, how those folks are being paid. None of that information is available so folks can know that we're keeping kids safe. Over the past few years, DCS has almost doubled its budget for residential placement from $385 million to a proposed $733 million in 25-26. The first part of this bill proposes that the department make available 3 years' worth of data on what entities are housing our youth, how much they're being paid, and basic information about licensing and violations and enforcement actions, because we're seeing problems with violations in some of these placements. We don't know the incident reporting, what that looks like, abuse investigations. These are things that we need to know about these entities. The second part of the bill requires DCS to report ongoing data on children staying in temporary placements like offices or transitional housing, shelters, emergency rooms. What we found out a couple of years ago were they were staying in offices for weeks on end, weeks. And we're talking about severely disabled kids that the folks tasked with sitting with them had no training on how to deal with those types of kids. And so I know that they're getting ready to get a new computer system that I think will help make this sort of data more readily available at the touch of a button, but that doesn't happen until October. And so we need to make sure that we are able to keep tabs on where these kids are when they're in transitional housings. We can report back where they are and make sure that they're being maintained safely in these things. We even saw in one facility, there was a pattern of young people having broken arms. These are incidences that you see a pattern. So when you have to report these incidents, this is how we find out about what is happening. Without reporting these type of incidences and abuse in some of these places, you don't get to see the pattern and you don't get to see what is happening. The comptroller's audit found that between March and September, children and youth stayed in temporary placements for lengths of time ranging from 1 to 160 days, with an average being 12 days. One youth stayed in an office for 104 nights. According to the commissioner's presentation to this committee in February, the assessment centers, which are supposed to be a maximum 30-day stay, are an average of 42 days. DCS should be required to share data about this problem, which has been an ongoing problem for at least 4 years with the legislature and the public. We should not have to wait for a comptroller's audit 3 years from now to know this information and have this information. We need to know who are the providers what we're paying to house kids, how they are paid, how many clients they serve. Any information that DCS needs to, they have the ability to redact. It's not like we're releasing private information. A lot of this would be aggregate information, like on abuse information and incident reports can be aggregate data without the names of the clients, but just so you can start to see those patterns that we sometimes find in these places. So that's what the bill does, and I'm staying ready to answer questions.
Any questions? Chairman Doggett?
Thank you, Lady Chair, and excuse me. I don't disagree with a lot of what you've said on this bill, but I do find some concern, Section E or subsection E at the very bottom about including a list, publishing a public list of locations where these children are going to be housed. And while we did read the comptroller's report, and there was a lot of things that we found there that was disturbing, at the same time, I feel like that would be a major safety issue for these children that we have put into this custody. You know, that's one of the things that I look at, because when I think about the world that we live in today, we just don't know what could happen. And if there's a list that says that there's 12 children in this location, what happens? You know, what could happen?
Well, it could be
Representative
just a
Johnson,
list.
you're
Thank you, I'm
recognized.
sorry. It could be a list just by county. I mean, the current placements, they're already out there. You can Google them and find them pinpointed. But the reality is this could be just what county. It doesn't have to be the exact address of that organization or that facility.
Chairman Doggett?
So, and that's, my colleague just asked that to me. If we already have that list available, why do we need to duplicate it?
Well,
Here.
Representative Johnson?
as things come on, as new facilities come on, that type of thing. And like I said, it doesn't even have to be a specific address, but it can be by county. It's important to know what facilities are available in what counties, and hopefully new organizations will be coming on because their numbers are doubling and tripling.
Chairman Doggett?
Thank you.
Any other questions? Representative Towns, you're recognized.
Thank you. Well, I mean, my concern, obviously, overall, I think is a good deal, but is there a way that the children are protected? Their names are not out there. You don't, no names, right?
No.
Okay. So Representative Doggett, there are no names. The people that are housed here, now that gives me a better feel for safety as it relates, because like I said, we got some crazy people in this world. I mean, we all know that. But if their name's not listed and they're doing something today, you said that they're already doing something today, you don't think that we're putting our children in any more jeopardy at all, do you?
No, I wouldn't. I certainly wouldn't want to put children in jeopardy. We will protect their name. Like we said, some of this is aggregate data, but Shelby County needs to know if a new, you've got to let people know that new facilities are on board. And and what might be out there that's available, because we have kids with such different levels of care needed. And a lot of times we don't do the best job communicating with the agencies that we contract with. You know, I hear from the agencies like, say, OmniVision and some of the organizations that do take on provide placement for some of our DCS kiddos. It's not happening fast enough. There's not enough information about who's available, what level housing that is. And just knowing all that, I think, and being transparent about it's important to keep a kid as close to home as you can. And sometimes it's best to move a kid, but you know, I trust the folks to be able to make those kinds of decisions. But this is protecting kids, but it's also being transparent so we don't end up with the kind of comptroller reports that we got.
You're recognized.
Thank you. As it relates to the children, we think this is going to better serve them and no jeopardy. And it will be also my question finally, who would actually, you think, the people that would use this information? Who would want to access?
Representative Johnson, you're recognized.
The folks that are serving these kiddos. Okay. I mean, it's, you know, the organizations I'm talking about, and then the people making decisions, you know, sometimes it's really difficult to get across what level child is, what level home a child needs. And what I'm hearing from my folks in Knoxville is they're getting sent the wrong levels. And so, you know, they're saying, well, we're sending you a level 1 kid. Well, we're not a level 1 facility, you know, that kind of thing. So, you know, maybe I'm hoping that this information we're getting a new computer system. I hope that this computer system will be a touch of a button so that we can know all these things. Because right now we have a very clunky dinosaur. But still yet, if this new system is able to produce this information, it'll be one button touch to get this information to the folks who need it.
Thank you.
Representative Alexander, you're recognized.
Thank you, Chairman, and thank you, Representative, for bringing this bill. Question for you. You had talked earlier about children being left in an office for longer than 100 and some days, but your bill talks about providers. Who do you mean by that then? Because if they're in DCS custody, they're the provider.
Well,
You're recognized.
We contract with a lot of folks. Like I said, OmniVision, Youth Villages, DCS contracts with them and they actually provide the foster home.
Okay.
You're recognized.
So would they be the ones that would be leaving the children in an office building?
No, that's DCS. That's DCS before they get to a foster home or provider.
Okay.
This is in the interim before this kiddo came in. They need this special kind of care. We don't have an appropriate placement for them. They keep them in transitional housing until they find a placement. And then later at the placement, that becomes the provider.
You're
But
recognized.
it's DCS while kids are in when kids are in transitional housing.
Okay. So your bill is in 2 parts.
Yes.
One for the provider, one while they're in interim before they
Well,
get to the provider.
Even when DCS contracts with you as a provider, those providers are responsible to let DCS know what they're doing. You know,
Yeah.
I mean, we can't just let them run free on their own. They're still accountable to DCS for the kids that they house. So it's just saying, this is making sure that everybody who has hands on a kiddo is accountable.
Representative Alexander.
And does this annual report go to DCS? Does it come to the state?
To
Who
the
does-
state,
Representative Johnson.
to the state, and
And who in the state?
let's see, we wanted to make it available to the state and to the legislature. Let me read that language. DCS should already have the information. Yeah. Just make it available to the state. It would be
Representative Johnson,
available.
is that on the website?
Huh?
Would that be on the website?
I mean, if they decided to put it on
It
the
is on the
website,
website.
they could.
It is on the website.
So that,
Does
you
that
know,
help you, Representative Alexander?
Yes, thank you
Okay.
very much.
Representative Alexander, do you have any more questions?
Well, just without knowing where it's going to go, I'm just concerned about if it just goes into La La Land and it goes on the website and whoever wants to see it can see it. But I just want it to have some teeth. Does
Well,
that
I
make
mean,
sense, what I'm saying? I just would like to see, is it going to the comptroller again? Is it going to the General Assembly? I'd like to see it specifically to know exactly where it's going to.
it goes to anybody who needs that information. If it goes to the state, if it goes on the website, then that means the legislature has access to it, the governor has access to it, DCS has access to it. It's all protected information, but those folks involved with those agencies all have access to it. We have access to it.
Thank you, Representative. Thank you, Chairman.
Any other questions? Without objection, we're going to call up DCS. We're going to go out of session. If you'll come up and introduce yourself. And the two of you have 5 minutes. Together, not separate.
Thank you, Chair Lady and members of the committee. My name is Jim Lehman. I'm Legislative Director for the Department of Children's Services, and Hayes O'Donnell is our Assistant Director. Excuse me. Again, the department had a position of flagged philosophically and flagged for fiscal reasons on this bill. So opposed to this piece of legislation. And again, we got to talk with Representative Johnson just a couple hours ago about it. A few things about our opposition to it. For one, there is a whole lot of information that we would be required to gather. That was sort of the cause for the fiscal note. Things, some of which we gather now, other parts of which we don't, but compiling things from lots of different places and putting them all together in one report would be a very extensive burden, time burden on us when, as you all know, we have lots of other things pulling us different ways. I'll read you a couple other things from our bill analysis. One of our concerns is that it requires publication of information of reported incidents and abuse investigations for our providers. We believe this would violate DCS confidentiality statutes as written, since DCS cannot release information pertaining to child abuse investigations. Second, the list of spaces that are identified as interim or short-term is expansive and includes assessment centers, hospitals, juvenile detention centers, and not just truly interim placements. So we feel that that definition there doesn't match, our current practice of interim placements. And then we did have a similar concern, as I think Chairman Doggett shared earlier, of we're concerned that the public release of all of these locations of placements would present a safety concern, particularly with those interim transitional placements. Many of those, are not things that are open to the public now and could, cause a safety concern for the kids that are there. So, and with that, we'd be happy to ask or answer any questions.
Are there any questions? Chairman Doggett.
Thank you, ma'am. So currently, is there these locations made available for people to be able to look at online to see where these housing locations are, the temporary, intermediate?
So
Mr. Lehman, you're going to.
I don't believe so on the interim, on these transitional type placements. I don't know that you could find those online. I'd have to get back to you to be sure, but I don't believe so. Chair Lady Littleton has a bill. Sorry, I missed part of committee, but about a database of locations of the agencies that we license. We actually are one of the few departments that don't have something similar to that, where you could look up, hey, if I wanted my child to go to a child care agency that DCS licenses, how would I find that? That'd be something, we'd be open to. We don't currently have, but many other departments have something similar. But with the interim placements, I don't think that you could find that information.
You ready?
Thank you. Do you currently keep this type of information that's being requested in this bill?
You're recognized.
I believe we have all the information that is in the bill. I think there is, again, some of it that would be a heavy lift to gather all together for all of the kids in custody. I think this is a very comprehensive report. I mean, we'd have to report this on all the kids. So one, the heavy lift of compiling that all together, and then two, the confidentiality concerns that I shared earlier about releasing specific information about investigations and that kind of thing. Sorry, go.
You're recognized.
Thank you. To expand upon what Jim is talking about, part of the violations of the confidentiality that is often recognized, it's in a couple of different places in statute. So just for reference, in public record, that is going to be 37-1409, 37-1612, 37-5104, if I'm reading my handwriting correctly, and then 10-7501 as well. And then addition to payments of vendors and whatnot, we do have a public-facing website as a state. It is the Transparent Tennessee Checkbook, and all of our provider payments are listed on there. You can search by provider, you can search by department, and that is not only available for DCS, but every single state department and each executive branch, well, executive, legislative, and judiciary.
Chairman Doggett?
Thank you.
Good. Any other questions for DCS? Seeing that, we'll go back. Thank y'all very much. We're back in session. Representative Johnson?
Thank you. I think that what we just heard is really important to be intellectually honest about. The incident and abuse numbers are aggregate. There's no names attached to them whatsoever. It's just information to say that, that this is happening. It's not attached to any person at all, so there's no identifying information there. The other thing is that transitional housing is so expansive that it's hard to keep up with. That's the problem. That is the problem, and that's why we need to have every child in transitional housing. There needs to be a report on what is happening there. So, and we've already addressed that the location can be a county. It's not a pinpointed address. But folks need to know what's available, what's there, why we're sending kids the way we're sending, or why we're keeping kids in transitional housing when there are placements available, because that's a huge problem in East Tennessee.
Any other questions for Representative Johnson? Questions been called. Could you open up the board, please? All those in favor of House Bill 2250, vote yes. Those opposed, vote no. Madam Clerk, would you take the vote, please?
Madam Chair, you have 1 aye and 4 nays.
Thank you, Madam Clerk. House Bill 2250 fails.
Thank you, Chair and Committee.
Your bills.
All right, where do we go? Now we're turning over the gavel to Chairman Doggett.
All right, we're on item number 1, House Bill 2526 by Chair Lady Littleton.
Motion.
Okay, there we go. Motion second. There you go. There's Amendment Code 14717. Amendment Code 14717.
We're a little. 14717.
Yes, ma'am. You have a motion and a second. You're recognized on the amendment.
Thank you, Mr. Chairman. This bill establishes a juvenile amendment review task force to make findings and recommendations in regards to the placement of children committed to DCS custody as dependent and neglected with violent behaviors, many of whom with pending serious delinquent charges. The task force will be composed of representatives from DCS, the Department of Mental Health and Substance Abuse, and the Department of Disability and Aging, the Commission of Children and Youth, the Council of Juvenile and Family Court Judges, the District Public Defenders Conference, a guardian ad litem, and several others. Secondly, the bill amends TCA 37-1-137B1D to add a determinate 6-month extension to the use commitment to the if the youth assaults a staff member while in DCS care. This will only apply to youth already adjudicated delinquent under the health and safety exception. The amendment ensures that the juvenile court plays a role in the process and the children have appropriate due process. With that, I ask for a favorable vote.
All right. The amendment must make the bill.
It does.
All
Sorry about
right.
that.
Any objection to the question on the amendment? All right. Seeing none, we're voting to adopt Amendment Code 14717 on the House Bill 2526. All those in favor say aye.
Aye.
Those opposed, the ayes prevail. You adopt or on your bill as amended. There is some folks here to testify.
There are.
So without objection, we will go out of session. We'll hear from Jim Lehman, Amy Smith, Keller Meisel. She not? That's all y'all right there? All right. I think y'all have 5 minutes tandem.
Thank you, Chairman and committee members. Again, my name is Jim Lehman. I'm Legislative Director for the Department of Children's Services. And Amy Smith is our Senior Supervisory Counsel. Thank you for the chance to testify on this bill. This is our administration bill, one of two that you'll hear today. This bill really attempted to address a couple of different things, and so we entitled it the Safe Environments Bill. There is an issue of juvenile courts bench ordering children into custody as dependent and neglected that have very serious delinquent charges. I sent each of you some data that we got from the courts on over the last few years, and it's really actually underreported because all of the courts aren't reporting yet, but very, very serious charges. I think there were 20 first-degree murder charges, several rape charges, attempted murder charges. And despite these charges, these children are bench ordered into custody as dependent and neglected. That creates a very unsafe and difficult situation for our staff because kids that are dependent and neglected cannot be put into a detention facility. So the goal of this legislation was never to put any and all foster children in detention. It was to address this very specific issue. And so we hope that the task force can look at this issue and determine recommendations on the best way to solve that. And then the second piece of the bill is a 6-month sort of sentencing enhancement for a very select group of kids. These are kids that are already adjudicated delinquent under the health and safety exception. They have an indeterminate sentence now. And if they are found to have committed assault against a staff member, then their stay could be extended by 6 months in the residential placement that they're at. This, we worked with the juvenile judges to make sure that the courts are involved here, that this is something that the court has decided has happened, not just the department. Since it's in court, the kids would be able to have an attorney and all those kind of things. So all the appropriate levels of due process. But again, trying to deter bad behavior in the facilities, not trying to have children any longer than they should be in these facilities, but just trying to deter that behavior on the front end. And that was part of the bill too, is that they'll be informed of this when they're being committed into custody, that, hey, if you commit an assault against a staff member, your sentence could be extended and that kind of thing. So really just hoping to deter that. And so with that, we'd be happy to answer any questions.
Thank you for that explanation. Any questions for our guest? I do have a couple questions for you since you're here. What is different between this amendment that we have before us versus the original bill? They look very different.
Right. So again, two main parts of the bill. The first part of the bill, the original bill, would have set up a mechanism where children that have these, offenses that they've been charged with, the ones that I talked about earlier, where they could be detained because they received a special classification. Again, we got a lot of feedback from stakeholders that, hey, this could be misused or that kind of thing, and not only address the issue that you're trying to address. And so we took that to heart and we said, okay, well, we don't want it to be misused. We'd like to just have a task force of all the different stakeholders that the chair lady mentioned look at this issue and say, hey, if this is not the solution, then what is? So that's part one. And then part two, about the 6-month enhancement. What's changed is more court involvement, number one. The court would be the one that disposes of this enhancement. And then two, much more narrow application. So it would only apply to the kids that are adjudicated delinquent under this health and safety exception, which is a specific subset of kids that I'm hoping Amy may be able to explain more of if there's more questions of that. But yeah. But those are the differences between the.
Okay, what about due process throughout this amendment here for these children?
Right. So the new language says that this would all be done in court. So the court would be able to implement all of the appropriate due process, including, giving the child an opportunity to present their case, present their side of the story, have an attorney present, all of those kinds of things.
And then my last question would be about the children and the youth that have disabilities. What effect would this legislation have on them?
Yes, I think very little, and I've talked to some stakeholders that had concerns about children with intellectual and developmental disabilities. A couple things. Many times, children with IDD are not adjudicated delinquent. They may be incompetent to stand trial, and if so, even if they would have committed an offense, if they're not adjudicated delinquent, it's not going to apply to them at all. So we have all sorts of kids that have IDDs that are in our custody as dependent and neglected. It would have no effect on them. We do have some that are adjudicated delinquent, even despite these disabilities, but we still have the ability to place children in the most appropriate placement for them, regardless of the charges that they have and that kind of thing. So these kids, many times with the very severe disabilities, are going to be with us until they're 19 anyway, just because their disabilities are not something that are going to be cured. And if they're so severely disabled that we need to be the ones watching them, then the 6 months enhancement isn't really going to impact them any differently, because they would have already been with us until they were 19 years old anyway. So again, all that to say, a very minimal impact on.
Very good. Any other questions for our guest? Seeing none, thank you both. Next on our list is Brittany Ruiz, Zoe Jamal. I'll give you both 2.5 minutes each. How about that?
I don't even need that much. That's
That'll
great.
be fine.
Okay.
Introduce yourself for the record and you'll have 2.5 minutes.
Awesome. Hi, Chair and members of the committee. My name is Brittany Ruiz. I am a volunteer for Citizens Commission on Human Rights, Tennessee chapter. And I was originally opposed to this bill, but I believe DCS in good faith made excellent amendments that put my mind at ease. And so I am neutral on this bill as it stands. And I think they are listening and they are concerned to all of the stakeholders. And I think the amendment addresses and actually puts a focus on what are the proper solutions without detaining incorrectly children. And so that's my testimony. Thank you.
Thank you. Ms. Zoe?
Yes, hi, I'm Zoe Jamil with Rafah Institute. My testimony today focuses on the bill sections permitting a 6-month extension of a youth sentence for staff assault, but I do want to note that the task force created by the bill may not be able to accomplish its stated goal due to prescribed limitations. I want to thank the sponsors for addressing many of the original bill's issues. However, the amendment does not answer questions about the process afforded to justice-involved youth who fall within its purview, and it effectively circumvents the current requirement that a court evaluate the youth's progress in completing evidence-based treatment prior to extending a youth sentence. The bill provides that a court may extend a sentence by 6 months if it finds a youth assaulted facility staff and an adjudication for assault is not required. There's nothing to guarantee the youth would have legal representation or an opportunity to present evidence in his or her defense. To extend a youth sentence for committing a crime, there should be clear process to ensure that the crime was indeed committed. It's important to note that assault is broadly defined in our code and includes behavior that doesn't cause injury. Because of prosecutorial discretion, not every act that qualifies as an assault is brought before the court, but under the bill, prosecutorial discretion goes out the window because no charge is required. This raises questions about the burden of proof and evidence required to make the assault finding. There is potential for this bill to exacerbate the placement issues that it creates the task force to solve by permitting a sentence extension for youth despite a provider recommendation that the youth be discharged to a community-based setting. Most youth in the juvenile justice system are committed to DCS custody for 6 months, and they shall not remain in custody longer unless the court finds that they need services or treatment from a qualified provider that are only available in custody. The court's determination is informed by a provider's treatment recommendation, which can consider an assault when evaluating the youth's progress. A provider may conclude that the youth has progressed and there's no benefit to remaining in custodial treatment despite an assault. That decision may be rooted in extenuating circumstances surrounding the incident, such as the child having a disability or the facility staff not following protocol or being properly trained in de-escalation. A tricky situation arises if a residential provider concludes the youth no longer requires treatment, but then the court relies on an incident report showing assault to override the recommendation. Does the provider go against their own recommendation despite opining that there would be no treatment benefit? If the provider instead discharges the youth from the program to make space for someone believed to benefit from it, this likely means the discharged youth goes to a juvenile detention center
Ms.
or
Sully.
other temporary setting.
We're out of our time.
Okay, can I address one thing that was said about disability?
Very briefly. Yes,
Okay.
please.
Young people with intellectual and developmental disabilities, as Mr. Lehman said, are adjudicated delinquent and often are placed in settings where they do not receive appropriate treatment. And sometimes that can contribute to an incident that involves an assault. And so I want to be really clear that there are conditions in facilities that can lead to this type of situation happening. And we should be mindful of that when we're talking about extending a sentence for an assault without a charge or any other process.
Any questions for our guest? Seeing none. Thank you both for being with us. We're going back into session. Chair Lady, you are recognized on your bill.
Thank you, Mr. Chairman. I ask for a favorable vote.
Any questions for the sponsor? Seeing none, Representative Towns, you're recognized. Question has been called. Any objections? Seeing none, we're voting to send House Bill 2526 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chair, you have 6 ayes and 0 noes.
The ayes prevail. House Bill 2526 as amended moves on to full judiciary. Item number 2, House Bill 2527 by Chair Lady Littleton.
Motion. Second.
You're
Thank-
recognized. There's Amendment Code 14757.
That's it.
Motion.
And a second on the amendment. You're recognized. You're recognized on the amendment.
Can we go ahead and put the amendment on, please?
We sure can, without objection. Voting to adopt Amendment Code 14757 on House Bill 2527. Those in favor say aye.
Aye.
Those opposed, the ayes prevail. You adopt for on your bill as amended.
Thank you, Mr. Chairman. This is another Department of Children's Services administrative bill. As amended, this bill requires instead of authorizes child protection teams to include a representative from one non-governmental agency specialized in combating the commercial sexual exploitation of minors for cases involving an allegation that a child is a victim of human trafficking offense. Requires members of every child protective team to annually complete 15 hours of training related to severe child abuse and child sexual abuse provided by the Department of Children's Services to be developed in consultation with the Administrative Office of the Courts, the State Chapter of Child Advocacy Centers, the Tennessee District Attorney General Conference, and the Tennessee Sheriff's Association and the Tennessee Association of Chief of Police. Requires DCS or a child protective team to determine if reported abuse was indicated or unfounded and report its findings to DCS Abuse Registry within 90 days after receiving the initial report and within 180 days after receiving the initial report if the investigation concerns a child fatality, and authorizes the Commissioner of DCS to provide one extension for up to 180 additional days for an investigation for good cause.
Thank you for that explanation. Are there any questions for the sponsor? Seeing none. Any objection to the question? Seeing none. We're voting to send House Bill 2527 as amended to full judiciary. Has everyone voted?
I guess I should vote for my own bill.
Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chair, you have 6 ayes and 0 noes.
The ayes prevail. House Bill 2527 as amended moves on to full judiciary. Let's jump to item number 16, House Bill 2350 by the Chair Lady Littleton. You're recognized on the bill.
Thank you, Mr. Chairman. This bill requires the Department of Children's Services to provide a copy of a petition of termination of parental rights or guardianship rights to a foster parent within 7 days of the filing of service of the document if the foster parent has served as the physical placement for the child for at least 9 consecutive months, and requires the foster parent to maintain such a petition as confidential information.
Thank you for that explanation. Any questions from the sponsor? Seeing none. We're now voting to send House Bill 2350 on to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chair, you have 6 ayes and 0 noes.
The ayes prevail. House Bill 2350 moves on to full judiciary. So that? Yeah, go ahead. There's that. Absolutely. I see my friend Deborah Moody sitting out there.
So just roll everything up next week.
What do I need to do?
What?
What do I?
Yeah.
All remaining bills we didn't get to will be rolled to next week. Without objection, we are adjourned.